Welcome to the Forgotten History of Women's Suffrage. We're so happy to have you with us today and to be where we are today. We're sitting in the chambers of Justice Sharon Lee of the Tennessee Supreme Court, and we are talking mostly about Ruth Bader Ginsburg. This program is really dedicated to her and for her service. We call the program RBG, a modern day suffragist, because much of what she did with her legal career in her life was to further the goals of the original suffrage movement. This morning, just to refresh myself, I read again the Declaration of Sentiments and the resolutions that were passed there, and they dealt with, way back in 1848, many of the very same issues that we're still dealing with today. Trying to get equal pay, trying to get equal access to voting, trying to get equal treatment in all ways for men and women. So, Justice Lee, I'm really excited to have you here. I think this is really, really nice, and thank you for letting us come into your chamber for this meeting. I'm just interested in what you have to say about the contributions Ruth Bader Ginsburg made to the advancement of the issues of women's equality.
Well, I think she had a unique role in that she was first an advocate for women's rights, or for equal rights, I would say, not just women's rights. She was an advocate, a very successful attorney for equality. She argued in numerous cases in front of the U.S. Supreme Court. She was very strategic in how she went about that. She did not ask for everything or ask for a sweeping change, but she was very careful in selecting the cases and seeking incremental changes and just essentially setting up building blocks. And she did it, she really pursued a standard of review, which for judges, especially appellate judges, is very critical. The standard of review that we use to review cases often is outcome determinative, and she knew that, so she advocated for a very strict standard of review in reviewing these statutes that she believed to be unfair to women and to men. Based on gender equality. And as it turned out, it was a slow, when you do it incrementally, it's successful, but it's very slow. You got to have a lot of patience in that regard. Right. And we saw that with the suffrage movement as well. Very slow. And we look back on that now and think, how could that have been so difficult? How could that, giving women the right to vote, why was that so difficult? It just seems like such a no-brainer now, but at the time, it took a long time, but they did the very best they could and barely crossed the finish line, even at that. So she began as an advocate, and I think part of that came from her experience. I don't think she started that way. She experienced gender discrimination out of law school, or in law school, actually. And I've heard that story from other women in law school. I never experienced that, but some of the professors would say, why are you here? Why are you taking up a seat of someone who would be more worthy?
What was it that the dean of Harvard Law School, there's a story where there were 500 students in the law school, only 9 of them were women, and the 9 women were invited to a dinner with the dean. Do you recall what he said?
And I think he said something like, why are you taking up a seat that a man could have and then be able to really use it, sort of thing. And I know, I had a friend who was graduated from law school, was ahead of me, but in the late 70s, who a professor called her in and said, why are you here? What does your husband think about this? Why does your husband think about you being in law school? And why would you want to be taking up the seat of someone? Something somewhat similar in the 70s, in the probably late 70s. And I know when I was practicing, I had an older lawyer stop me one day, and I was checking a title in the Register of Deeds office. And he said, why are you here? And I said, here, I'm checking a title, that's the only place you can do this. And he said, no, why are you a lawyer? And I was not offended by it because he was truly mystified as to why I wanted to be a lawyer. And if there wasn't any hostility or any ill will with that question, he just didn't understand. Mm-hmm. And I just said, the same reason you are. It's just what I want to do. So I think Ruth Bader Ginsburg experienced that in law school. And then as being a top graduate of an Ivy League law school, she still couldn't get a job. Sandra Day O'Connor had a similar experience. Could, obviously outstanding, very well qualified. And a man in their positions would have had picked up jobs. They couldn't get jobs.
Sandra Day O'Connor had to take a job as a stenographer.
I think you're right, yeah.
That's
and then eventually, didn't have the best jobs. I mean, really struggled to get any kind of job. And then finally got on the Court of Appeals, was active in the state legislature and politics, and I think that's kind of what got her then into the Court of Appeals. And then President Reagan appointed her while she was on the intermediate court, state court, which is really unusual. I mean, that's just, you don't see those kind of picks from a state intermediate court. We've not seen that since. I'm not sure, that was a very special case, but she was extraordinary.
Wow.
So Ruth Bader Ginsburg experienced the discrimination in law school and in the job market, and then I think gravitated toward the ACLU and different organizations that realized she had extraordinary talent and got her in on these cases. And
well, when I was in law school I started in '79, so in the early '80s, when I first read the Bakke decision and some of the other decisions that she was involved in, I was really kind of annoyed. And I was annoyed because it seemed like the only progress that we were seeing in the courts on women's rights were because men were disadvantaged somehow by the discrimination that women had also faced. And it seemed kind of backwards to me. And I wasn't sure whether to feel annoyed with the courts, if the courts were just only concerned about discrimination when it affected men. But now I understand much better.
Well, yeah, you're right. It makes sense. Those were the easier cases to win, and you could establish legal principles on which you could build. But that requires somebody very forward-thinking
and very patient.
And she that was exactly, I think, the key to her success as an advocate.
Yes.
And I mean, it did take a long time.
She's a pretty small, petite person, 5'1". That's probably worked against her as well.
Yeah, I'm sure it did.
People tend to be more dismissive of people that are small. So
you combine that with being a woman, and you've got a double dismissive situation.
Exactly. Well, what of her decisions do you think was the most important, if you can?
I think the VMI, the Virginia Military Institute decision, where
tell our audience a little bit about the background of VMI and why you think that was an important decision.
Well, it was a military school in Virginia that had an all-male admissions policy. And so you had the separate but equal type theory trying to apply to that to women, the same as we had with racial issues back in the 50s. And she said, it's not fair to women, essentially overturned the all-male admissions policy. And she wrote in that opinion, generalizations about the way women are, estimates of what is appropriate for most women, no longer justify denying opportunity to women whose talent and capacity place them outside the average descriptions. Because in that case, they brought in evidence, that most women can't do this, or most women can't do that, and she just said, no, those generalizations don't work anymore. I thought that was huge, and then that opened the door for women to be admitted to VMI, and then the Citadel followed, the Citadel and different all over the country, the military schools. So that one always stood out in my mind, I think. The Shelby County, the voting rights case, which that was in her, that was, she did a lot of her important work in her dissents. And of course, she dissented there and said, the Voting Rights Act gave us certain protections, and yeah, it's working, but she had the great quote that throwing out pre-clearance when it's worked and it's continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you're not getting wet. That was just a beautiful way to describe how the Voting Rights Act was helping.
So what at issue in that case was the
Oversight.
pre-clearance, the oversight.
Oversight, where certain jurisdictions with a history of discrimination had to undergo federal oversight before enacting any new changes.
So they couldn't change the way you voted or anything about
just certain suspect areas which were clearly discriminating. The court threw those out and said, no, we don't need this anymore. Things are going well.
What were some of the things that happened in some jurisdictions, including the South, that caused the court or Congress to originally enact the Voting Rights Act? What kinds of things was it intended to stop?
I'm not sure I know. I'm thinking of, there's always been the poll tax, the certain educational requirements. That was back years ago. I'm not sure what specifically caused this, but I know there's always been, a history of suppressing vote. We still may be having that even today.
Perhaps.
And I don't understand why you would ever want to suppress a vote, but we have had a history of, particularly with, as we know, with women.
Well, those efforts usually are directed at a group that they assume will vote one way or another.
Right.
And then try to keep
And I think it was a lot directed to African Americans.
Yes.
Initially, the Voting Rights Act, when it was passed, was directed to eliminate discrimination against African Americans and make it not easier. I won't say make it easier for them to vote, but enable them to vote.
Right. Remove the roadblocks.
In terms of registration, remove registration, roadblocks, and that sort of thing.
Okay. And that's hugely important, especially
And
this year's election is a study in fear and concern.
It's true. And then the Holder decision, or the Shelby County decision, came out in 2013. And she was right to say in that case, look, it's not over. There's still discriminatory practices regarding voting. And we can't just say we've conquered this, we need to move on to the next battle.
Her umbrella comment was to address really what the majority said in that case, which was, well, we don't see voter suppression happening like it used to historically, so we no longer need to have oversight. And that's what she said. Throw away your umbrella in the rain because you're not getting wet.
And things have improved. I mean, no doubt things have improved, but in certain places there still needs to be oversight, just so they don't revert back to the discriminatory practices. But she was a dissent. And then the Ledbetter, the Fair Pay Act, Ledbetter versus Goodyear Tire, that was a dissent, but that was so beautiful because she basically, it was a Fair Pay Act. Woman worked all these years and realized she had not been earning as much as her male counterparts. Brought an action, and then it sort of turned on whether she had done it timely, a very technical sort of statute of limitations issue. And Justice Ginsburg dissented and invited the legislature to come in and fix it, which they did. The president, that was one of President Obama's first things in office, was to come in and
pass the Lilly Ledbetter Act.
Pass the Lilly Ledbetter Act, which, when you think about whether a dissent is successful, that one has to rank right up there as being incredibly successful. And perhaps she sort of knew it was going to be, just from looking maybe hopeful that he would be elected, that Congress would be supportive. But you look at that and you think, why wouldn't you have equal pay? I mean, what's the argument against
because the employer can keep more money in their pocket.
Yeah, that is. So,
hire a woman, it's cheaper thing.
Right. And then she's been, the Hobby Lobby case and the Affordable Care Act case. He really stood up for women in terms of contraception and being able to have access to contraception.
What was the issue in Hobby Lobby?
Hobby Lobby was, we had an employer who...
This is fun, I get to ask you the questions.
Oh, I know, and I'm thinking, wait a minute, I like to be on the questioning side. I'm reverting back to being a lawyer and trying to scramble for answers. But the court in 2014 Yeah, I'll pay you back for this sometime if you ever come into court. That certain for-profit companies, Hobby Lobby,
Right.
can't be required by the government to pay for certain types of contraception, such as methods of birth control and emergency contraception for their employees. And Hobby Lobby, the governing board or the president, whatever, management, didn't want to pay for, didn't believe in that, and they argued that for, I guess, religious reasons, they shouldn't have to do that, and the court went along with it. But in her dissent, she wrote that the court had ventured into a minefield, adding that it would disadvantage those employees who do not share their employer's religious beliefs. And any decision to use contraceptives made by a woman covered under Hobby Lobby's plan will not be propelled by the government. It will be the woman's autonomous choice, informed by the physician she consults. And she was also very aware that the cost barriers that women face in getting birth control. Because the cost of an IUD is nearly equivalent to a month's full-time pay for workers earning minimum wage. So she was very aware of the practical effect of that decision on women. Not just the interesting issue of should Hobby Lobby be required to provide contraception, but how's this really going to affect a woman making minimum wage? Well, the effect is she can't get birth control because she can't afford it. And I'm sure that was an argument provided, well, if we not provide it through insurance, they can go buy it on their own. Well, no, that's not the way the real world works for a minimum wage employee. So that I thought was an important issue. And you know, she gave an interesting speech back a number of years ago about Roe v. Wade, and in that she made somewhat of a controversial statement that she didn't necessarily agree with. She agreed with the result of Roe v. Wade, but she thought the court made such a sweeping, she criticized the court for making such a sweeping change that Roe v. Wade was never really accepted by the majority of people. And it has remained controversial over all these years because the court took such a huge bite out of the apple, or maybe the entire apple, and didn't make the small nibbling bites that she had done in her incremental approach to gender equality or equal rights for everyone. But she advocated that incremental change because it made it more socially acceptable, and Roe v. Wade made such a huge change. And there's some logic to that, and it may help explain why Roe v. Wade continues to be so controversial. Although, you could make the same argument with when the suffrage is like, they got the whole right to vote at one time, that was controversial, but how else are you going to do it? You know, I mean, you either, with women's suffrage, they either vote or they don't.
Really,
so
they did do a little bit of working their way there.
A little bit.
There was some states gave women the right to vote on school board elections or some municipal elections or bits and pieces here and there. And of course, the states in the far west were much more generous with the right to vote, with the exception perhaps of Washington, which had a couple of missteps in their process. But
it was such a patchwork. It was such a patchwork.
It was a patchwork, but because 72 years the issue had been on the table, it didn't come up overnight and change. I think it probably did have less resistance after the fact. And I can't help but think about the Civil War and how much resentment remained in the South for how long after the Civil War. And that was a huge change, all at once. And maybe it had to be that way. I can't imagine that it could be any other way. At least I can't think about that. But it is hard to make major ground shifting kinds of
especially a big policy
change.
A big policy change coming from the court, not the elected representatives.
And kind of like the masks.
Right. And you can harken back to Brown versus Board of Education, which the court held, mandated integration of schools, bans, interdictions. We look back on that and think, why not? I mean, we think that was such an easy decision. At that time, it was incredibly controversial.
Right.
And it was also a policy decision that the court had to make because the Congress wouldn't do it. I mean, if we'd left it to Congress, when would we have achieved integration? It would have been a decade or more.
Excruciatingly slow.
Very, very slow. So the court made that, and that was a time where the court stepped in, made a policy decision. And there's always that tension of, should the court be making policy decisions? That was the case where they should have.
Right.
And it was a sweeping change, and it was controversial, but it was the right thing to do.
Well, certainly Ruth Bader Ginsburg spent her life in the middle of controversy. I think we could say that. And always seemed so cool about it. And one of my favorite quotes, and I'm going to get it wrong because I didn't write it down, but it was something to the effect that you shouldn't waste our time with anger and frustration. When things don't work out the way you want them to work out, you just keep moving. And she's a great example of that. And that is, in my view, it's really the spirit of the suffragists to do that. So I think she had a suffragist spirit.
Oh, absolutely.
And
she did.
And I suspect if she had been born earlier, she would have been a leader in that movement as well.
She would have been.
Well, it's been a joy to sit here and just talk about this with you
It's been
and
fun.
think about some of the wonderful things that she's done. And did she address, let's see, she did equal pay, that's the Ledbetter case. She
A dissent in voting rights case.
And she dissented in the voting rights case. She did try to get to, did she do any, yes, VMIs, an education case,
yeah.
access to education and access to professions as a result of that education. So she addressed that.
Well, I mean, she was on the court so long. I mean, her decisions really have touched probably every area of the law. These are the ones we've talked about, are just a few of the ones, but she was a very gifted writer. She was very careful in her writing and very precise and a wordsmith and very just incredibly hardworking.
How many women were in the law school when you went to law school?
Actually, there were quite a few. I graduated in '78. There were, so probably the number in my class was equally the number in your class.
Just about.
But what happens is they don't make it into practice, or they don't last long in practice. You've got that leaky pipeline, as they say.
Right.
So when I got out and started I had women around me in law school. I didn't think much about it. But when I got out into practice, I never saw another woman. I mean, I was the only one in my county, maybe another woman in my district, but there was no women judges. Very often mistaken for the court reporter.
Right.
When you go to court.
Yes.
So I know I came to court once in Knox County and was just like, what are these women doing here? This is amazing. There's other women lawyers besides me. So, I just practiced in an area where I was really the only one for a long time.
Wow.
So I think, whereas I had a lot of women in my class, they didn't go into practice.
But do you ever feel like the privilege of going to law school and being able to practice law is probably due in some part to the work that Ruth Bader Ginsburg did?
Absolutely. Yeah.
Opening the doors. I know when I started law school, a lot of the women who were in the law school were legacies. Their fathers or their uncles or grandfathers were lawyers and known to be, and they were able to get into law school by legacy at some points. Some law schools still do some legacy admissions, but just regular people.
And I think her position on the Supreme Court, when you can see something, then you can believe you can do it. You've got to see it to believe it, basically.
Right.
So women saw her as a justice, and that women lawyers started thinking, well, I can be a judge. Now, I never saw myself as a judge because I never saw any women judges really in my area. And then I decided to run for judge, and people would like, can women be judges? Like, well, yeah, they can. But young women now have so many examples of women judges, women lawyers.
Well, you were the first judge on the Eastern Section Court of Appeals, first woman judge.
And at that point, the court had been in existence 79 years. I served 4 years, and we just this year, so I served from 2004 to 2008. It took another 12 years to get a woman back on the Eastern Section, Judge Christy Davis. So There's been two women judges
In all that time.
all that time. And part of that is we don't have an equal number of women lawyers, so the pool is smaller. And then often women, we've got a circuit court vacancy now, no women applied for that. So women have to often, they're a little more cautious, I think, about putting themselves out there. And I always encourage women, think like a man. Yep, you can do it. You can do it. Have that confidence. And say you apply or you run for office and you don't win, it's not the end of the world.
Okay, well, thank you again so much for coming and being a part of this and letting us come into your chambers. And now very quickly for Did You Know? Did you know that Ruth Bader Ginsburg argued the case Durham versus Missouri, which was over an blanket exemption for women to avoid jury service. And at the end of that argument, or toward the end of that argument, she was asked by then sitting Judge Rehnquist, and it's his seat that she now held until just a few days ago, will you not just settle for putting Susan B. Anthony on the dollar? And dismissed her argument that way. So at least Justice Rehnquist thought about suffrage, I guess, when he saw Ruth Bader Ginsburg as well. Did you ever get to meet Ruth Bader Ginsburg?
I did. I attended a National Women Judges Association conference in Washington, D.C., and she was a featured speaker. She was very, very small, very petite, very thin, very delicate looking, wore gloves. But when I saw her sitting on the stage and I thought, is she going to even be able to speak? But when she started talking, it was very powerful. I was very, very impressed. And I met her at another reception as well, but very sort of timid, very withdrawn, but so powerful when she would speak. So I was very impressed.
Well, you were really lucky. And you have your granddaughters.
I do.
Some interest. Tell me a little bit
Well,
about
I have two granddaughters. They're now 5 years old. But when they were just babies, I made little robes for them, and I would bring them up, and we would have a picture made on the bench. And so last year there were 4, and I dressed them up I added lace collars to their robes and gave them little classes. So we did a Ruth Bader Ginsburg look-alike picture session in the courtroom, and I had some really cute pictures of them, and I did a collage, did 4 pictures, mailed it to Ruth Bader Ginsburg and said, these are my granddaughters, thank you for inspiring them, and just a letter to her, basically, a fan letter is what it was. And I said, would you autograph this and send it back? And she did almost immediately, and I was so impressed, and I have it framed and hanging on my wall now. So
what a wonderful.
And that's something the girls will always treasure.
Absolutely.
Yeah.
Absolutely. That's terrific. Thank you again.
Thank you.
Be sure to come back and watch us next week.